Good morning, good afternoon, good evening to everybody, and welcome to this C2LI webinar on project-based climate change litigation in Africa. My name is Francesco Sindico. I am the founder and director of the Climate Change Litigation Initiative at the University of Strathclyde Law School in collaboration with the National University of Singapore and the University of Geneva. Before I start, a huge thanks to my two colleagues, Lydia Omuko-Jung and Amelia Burnett, both C2LI legal analysts, for organizing and bringing together this webinar. Before I start sharing the actual webinar and also introducing the speakers, let me just share with you that C2LI, the Climate Change Litigation Initiative, has very much become, and will be even more in the future, a hub of knowledge on climate change litigation, presenting information about climate change litigation in 30 countries and growing around 3 specific scenarios. And today's webinar focuses on the second scenario that C2LI covers in its initiative. And this is the one that really focuses on project-based focused climate change litigation, and we will be focusing on the African continent with a specific focus on South Africa, Kenya, and Nigeria. And to do this, we have 3 fantastic speakers. I will introduce them one after the other now, and then continue my brief introduction. The first one will be Nicole Lawson. She's Program Head, Pollution and Climate Change at Center for Environmental Rights in South Africa, and she's based in Cape Town. Our second speaker is Mark Odgada. Mark is Program Manager at Natural Justice in Kenya. And our third speaker is Dr. Pedi Obani, who is an Assistant Professor at the School of Law at the University of Bradford. This is not the first C2LI webinar. We have done quite a few actually over the past year. We organized one back in November 2020, focusing very much on recent developments in Brazil. And we then had 2 other webinars focusing on the first scenario, which is really about cases against the state as a whole for ineffective climate action. And both of them were organized in collaboration with partners in Latin America, the Externado University in Colombia and the University of Chile. But they had a very much Latin American flavor. And with today's webinar, we're moving continents and we're really focusing on the African continent. We are planning in due course to organize also a webinar on scenario 3, which is about challenging and bringing to court private actors when it comes to their climate change operations. And for that webinar, we'll be focusing on Southeast Asia, and we will be doing it together with the National University of Singapore. C2LI will be launched at COP26 on Saturday, the 6th of November. So save the date, both if you will be in Glasgow or if you will not be in Glasgow. We'll be organizing a major event on climate change litigation and the rule of law in collaboration with the LSE Grantham Center for Climate Change and the Environment and the IUCN World Commission on Environmental Law. And I'm sure that during the webinar, we can provide more information about that event. The webpage, the C2LI webpage, the portal will be opened at COP26. And let me take advantage of this opportunity to give a huge thanks to all those who have been involved. C2LI has been a major endeavor, bringing together C2LI legal analysts, senior research assistant practitioners, national rapporteurs, and in particular to the many people who have joined C2LI over the past month and a half as a focus group to really help us get constructive and critical feedback and criticism to the webpage. So what you will see opening at COP26 is really the result of also their hard work. Now, before we start, just some housekeeping. You, as always, in a Zoom webinar, you have a Q&A box. So please use the Q&A box to put your questions. These will be collated by Lydia and Emilia and passed on to me for the Q&A session. We are planning throughout the presentations of our three speakers to disable the chat so we can sit back in our hopefully comfortable chairs and really enjoy the three presentations. We will, however, reopen the chat once we have the Q&A, and you can use the chat to share more comments or even introduce yourselves and provide a bit more information about yourself, but just during the Q&A. So without further ado, I give the floor to our first speaker, Nicole Lawson from South Africa. Nicole, the floor is yours. You'll have 15 minutes.
Thank you very much, Francesco. Hello, everyone. It is a pleasure and a privilege to be able to talk with you a bit today about our work. My name is Nicole Lawson. I am an attorney and I head up the Pollution and Climate Change program at the Centre for Environmental Rights in South Africa. We are essentially a group of activist lawyers. We work with communities and civil society organizations in South Africa to realize our constitutional right to a healthy environment, and we do this by advocating and litigating for environmental justice. Now, over the years, my work has to a large extent entailed opposing proposed new coal projects in South Africa, which is probably why I am on this panel today. So just to give you a bit of background and context, South Africa as a country is extremely vulnerable to the impacts of climate change. At the same time, the majority of our electricity comes from coal. The energy sector is by far the largest contributor to greenhouse gas emissions in South Africa. And at the same time, government has plans to develop more fossil fuel electricity capacity from coal and now from gas. So this map is actually a few years old now, but essentially the little black dots are all existing coal plants in South Africa. And the purple dots are proposed new coal-fired power stations that government wanted to go ahead and build in South Africa. I can say with some immense satisfaction that none of them have been able to go ahead. And I'll get into that shortly. But just to say that, South Africa faces many challenges, including deeply entrenched inequality. And we know that the effects of the climate crisis threaten to exacerbate existing human rights threats, particularly for women and for children, as well as future generations. So in light of all of this, and especially from a human rights perspective, it is essential that we do our utmost to reduce greenhouse gas emissions in South Africa and our exposure to the impacts of the climate crisis. So in seeking to do this, we really over the years have worked really hard to oppose proposed new coal projects in the country. On behalf of a number of community-based and environmental justice organizations, including Groundwork and Earthlife Africa. Those are two of the organizations that we've represented largely in the litigation that we've brought. So I'll just tell you a bit about one of our first coal opposition projects that went to court in 2017. So one of our first coal project challenges was the case of Earthlife Africa versus the Minister of Environmental Affairs and others, also known as the Thabametsi case. This photo was taken outside the courtroom in March 2017 when the case was heard. So in this case, on behalf of Earthlife Africa, we challenged the Minister of Environment's decision to allow a proposed 1,200 megawatt coal plant, the proposed Thabametsi coal plant, to go ahead without first assessing the climate impacts of the project. So what the minister did is she did order them to do a climate impact assessment. She said that they needed to assess the climate impacts, but she upheld the environmental authorization. So effectively, any climate impact assessment that Thabametsi did would have had no bearing on the decision to allow the project to go ahead, which is why we took that decision on review. We argued that any assessment of climate impacts needed to be done before a decision could have been made to authorize the project. Otherwise, you're simply rendering it a tick box exercise. So So two questions needed to be answered in this case. Firstly, whether under South African law there is a duty to consider climate impacts as part of an environmental impact assessment process. The second question was, if there is a duty to assess climate impacts, then did Thabametsi adequately assess the climate impacts of the project? So what they did in their environmental impact assessment was they provided a mere cursory one-liner that said the project's a coal plant, it's going to emit greenhouse gases, this will contribute to global warming, but in the global context, the impacts are regarded as insignificant. That was the extent of Thabametsi's climate impact assessment initially. But remember, they had been ordered by the minister to do a climate impact assessment in the interim and while this case was going on. So we argued that under South Africa's environmental laws that regulate environmental impact assessments, there is a clear duty to assess climate impacts as relevant factors in assessing the environmental impacts of proposed projects. The minister and Thabametsi argued that there's no legal basis for needing to assess climate impacts. It's not specifically required in South African law. They also said that the assessment that Thabametsi had done was adequate, that the minister simply ordered Thabametsi to do a climate impact assessment for data gathering purposes, but not because she deemed the climate impact assessment to be inadequate. They also said that because South Africa's electricity planning policy specifically calls for coal power, and because that policy considered climate impacts, that there was no need to assess the climate impacts at a project level. So interestingly, shortly before the case went to court, Thabametsi made its climate impact assessment available, and lo and behold, what we received was a very comprehensive, very detailed document which confirmed that the project's climate impacts would be very high. From a greenhouse gas emissions perspective, it was said to be one of the most greenhouse gas emission intensive coal plants in the world. And then interestingly, they also flagged climate as a very high risk for the project itself, given that it would have been based in a water scarce area. So then what we had was a very clear indication that the assessment that they had initially done was clearly inadequate and nothing in comparison to what they subsequently provided. So this was quite a useful piece of ammunition in our court case. So the matter then went to court in March 2017, and a few days later, the judgment was handed down, and it was handed down in favor of our clients, Earthlife. The court confirmed that a plain interpretation of our environmental impact assessment regulations and our environmental legislation confirms that there is a duty to consider climate impacts, that climate impacts are relevant factors that must be considered in assessing the environmental impacts of projects, particularly a project as emission intensive and climate harmful as a coal plant. So this was quite an unprecedented decision. And the court also confirmed that the climate impact assessment that Thabametsi had done initially was woefully inadequate. And what was really great about this decision is that the court confirmed the need for a comprehensive climate impact assessment, not just a quantification of greenhouse gases, but something much more in depth than that. And just this quote from the judgment is quite nice. I like to refer to it quite often. So what we ended up with was quite a nice and progressive judgment from the High Court. So essentially, the minister was ordered to go back, reconsider the climate impact assessment, and make a decision again on our client's appeal of the environmental authorization. So some months later, the minister went back, she looked at the climate impact assessment, and she decided to uphold the authorization once again. This time, she said that she considered the climate impacts, but because South Africa's electricity policy talks about the need for coal power, any harms of the project were far outweighed by the need for this electricity capacity. So we took that decision to court, again on behalf of Earthlife, and this time also on behalf of Groundwork. And here we argued that the minister had unreasonably and unlawfully fettered her discretion because she essentially treated this electricity policy as determinative of her decision to the exclusion of project-specific, very high climate impacts. So that case, shortly before it was set to be set down for hearing, we actually received an offer of settlement from the department saying that they would agree to set aside the environmental authorization. Thabametsi also agreed. So this case didn't actually, the second Thabametsi case never got its day in court, but the practical effects were essentially the same, and that the environmental authorization was subsequently set aside, and that judgment was handed down last year, judgment by agreement, towards the end of last year, and then everything for Thabametsi kind of fell apart. The last of the financiers that was set to finance the project pulled out, and then Thabametsi also withdrew its position as preferred bidder in South Africa's coal procurement process. So essentially that project has now been laid to rest, much to our relief. So maybe just to talk a little bit about some of the effects of that judgment and our work there. So firstly, the judgment confirmed and provided us with a very important precedent, confirming that there is a need to assess climate impacts as part of environmental impact assessments for projects that would have significant climate impacts. This means that the days of the cursory one-liner saying that climate impacts aren't expected to be large in the global context, those days are now hopefully over. And government has actually now released a draft guideline for climate impact assessments, which essentially requires quite a comprehensive climate impact assessment to be done. So not at all a bad result that we've seen there. It also means that, you know, if climate impacts are properly assessed, we should be seeing more authorizations being refused, particularly for projects like coal power stations, just given the extent of the climate impacts of these kinds of projects and the fact that they can't really be mitigated. But very importantly, this Thabametsi judgment, the 2017 judgment, opened the door for a number of other coal challenges. And on the basis of that judgment, we challenged a number of other proposed coal projects also for their failure to adequately assess climate impacts. One of the other more significant of these coal plant challenges was the challenge of the Kanisa coal-fired power station. And earlier this year, we also got a judgment in that matter, essentially confirming that the environmental authorization lapsed because of the legal disputes against this project and a number of other coal projects meant that essentially the environmental authorizations lapsed given the time and the delays that were being caused for these projects. So maybe just from a practical perspective, the real world outcomes of this Thabametsi legal challenge and the other legal challenges of proposed coal projects in South Africa. As I said in the beginning, one of the most tangible outcomes is that none of these coal projects have been able to go ahead. The legal challenges against these projects, as I've said, have meant they've been massively delayed and held up with legal opposition and legal battles. So just in terms of the Thabametsi and the Kanisa coal projects alone, these are the two of the projects that we've successfully challenged in court. Stopping just these two projects has meant that 212 million tons of greenhouse gas emissions will never enter the atmosphere. More than 720,000 cubic meters of precious water per annum has been saved for 30 years. It's also meant that significant air pollution that would have harmed the lives of people in the areas where the projects were proposed has been avoided. And these coal projects were also being proposed in areas where there's already existing coal-fired power and significant devastating air pollution. And from a cost perspective, having these projects set aside has also meant that the South African public has been essentially spared 19.3 billion rand compared to a least cost electricity system that would not include this new coal. So maybe just finally, just to talk a little bit about some of the lessons that we've learned in these challenges that we've brought against these coal-fired power stations. So I should just probably say that, you know, the strategy has been a multifaceted one. Not only have we been challenging multiple coal projects, but the challenges have been against various different licenses and processes and authorizations. So to give you an example, we've had to challenge each project needs an environmental authorization, a water use license, a waste management license, an air emission license, an electricity generation license from our energy regulator. And all of these have their own processes. And then in addition to the legal challenges, we've also had to embark on extensive advocacy campaigns, mobilizing with communities to oppose these projects. And I think I mentioned this already, we also engaged with the financial institutions that were going to finance these coal projects. So what this has meant is, you know, it's been a highly effective strategy to really, if not stop these projects, to substantially delay them, because the more you can delay them, the less appealing they look to financial institutions and to governments. And as I've said, none of these coal projects have managed to go ahead. In 2016, we saw about 14 of them applying for environmental authorizations, and they've all been stalled. And this, again, you know, part of it has been legal opposition, but also a large part of it has been working with communities who have been doing extensive mobilization on the ground. So it's certainly been a collaborative and very important joint effort. One thing I can say, though, is that this kind of strategy where you're challenging in one project from multiple angles is highly resource intensive. It requires a lot of time, a lot of resources. So I would say that that's probably one of the challenges associated with following this kind of approach, despite it being very effective. And then finally, just lastly, I would maybe just like to emphasize the importance of having opposition backed up and supported by credible, independent expert reports. That's been something that we've relied on quite heavily, certainly in our advocacy and our litigation in challenging proposed coal projects in South Africa, and it's proved to be highly effective, especially to be able to show not only the greenhouse gas emissions and other kinds of quantifiable pollutant emissions, but importantly, to be able to show how much these projects are going to cost. That's also something that's managed to gain quite a bit of traction. I think I'll leave it at that. Thank you very much. I hope I haven't run too harsh over time. Okay, thank you.
Not too much. Thank you very much, Nicole. That was absolutely brilliant. If you can stop sharing, I would appreciate it. Thanks. That was an absolutely superlative journey of the South African case and also the South African environment. And one thing I really enjoyed was the discussion, not just about the legal nuances of the case, but also the journey afterwards and the effectiveness and what actually happened. Because often we are really interested in the legal issues, and then what kind of question. So it was interesting to hear an answer to that, then what, and I'm sure in the Q&A I already see some questions about it. So I'll be happy to pose them to our speakers. But let's move on. We take journey north in Africa. We move from South Africa to Kenya, and I now give the floor to Mark.
Thank you. Just checking to see if you can see my screen.
We can, if you can put it in full slide mode. Perfect. I will let you go now.
Thank you. It's great to be part of this discussion, and I'm really excited to see how C2LI grows to, I think, highlight and capture and I think share more stories about cases like this. So I work with Natural Justice, and we are an environmental organization. We work with and support communities to secure their social and environmental justice rights. We're headquartered in Cape Town, South Africa. We have offices in Dakar as well as Nairobi. So I'm currently joining you from our office in Nairobi. And so today I'm just going to share a little bit about project-based climate litigation, just to set a bit of the context of why it can be an effective way to raise climate challenges and to push for climate action. And some of the lessons learned specifically in the context of Save Lamu versus the National Environment Management Authority and Amu Power, a case that was lodged in 2016 and decided in 2019. So I think I'm going to start just with a little bit of a context, and this is very Africa specific. I think the one thing that I think most countries will, and most people from different jurisdictions will recognize is there's a huge push currently on the continent to bridge the infrastructure and development gap. And so we are seeing in different countries that there are huge mega infrastructure projects, and these are anchored in trying to make the continent and different countries more globally competitive, to make ease of extraction of resources better, and to improve the economic growth. So that's one side of the coin, and there's a huge infrastructure push, and we'll see right from the AU that there's various frameworks that have been set up to do that. And when you go to different countries, you find various economic blueprints that are also, sort of anchoring infrastructure development at the core of what they do. Now, the other side of this coin is, of course, the climate crisis. Most of us will be familiar with the 6th assessment report by IPCC. Before this, there have been numerous reports that have, I think, specifically zeroed in on Africa, capturing the fact that Africa, despite having contributed historically the least to greenhouse gas emissions, stands to suffer some of the harshest impacts. I think it's exacerbated when you consider that quite a huge percentage of the population are made vulnerable. They have a low adaptive capacity, and poverty also exacerbates all these impacts. And I think the 6th assessment report by the IPCC, I think just clarifies that. And so there's a tension between the right to development, which most governments are pursuing, and on one hand, and on the other hand, there's climate impacts that we need to consider. And I think this comes particularly in stark focus when we're talking about fossil fuel projects, when we're talking about energy projects, and the tension between trying to bridge that gap, energy access, and how to do it as most countries see it quickly, effectively, and affordably. So that brings us, I think, very neatly to the case of Kenya, because when you're talking about the proposed coal-fired power plant in Lamu, the starting point is, of course, Vision 2030. And as I mentioned, a number of African countries are anchoring this infrastructure development push in economic blueprints. In Kenya, this is Vision 2030. And as part of Vision 2030, sometime in 2013, to meet all the industrial growth projections or projects that were in place, the government put in place this ambitious plan to increase our energy capacity by 5,000 megawatts, I think, within a 14-month period. And it's in this context that then the Lamu coal plant was proposed. The coal plant was to be established in Kwasasi, which is in Lamu. So it's 21 kilometers from Lamu Old Town, which is a UNESCO World Heritage Site. And close proximity to the proposed site of the coal plant is also a biosphere reserve and sensitive marine ecosystems, which have been the source of livelihood for the people of Lamu for centuries. And I think it's one of the oldest Swahili settlements on the continent. And so against this idyllic, very pristine ecosystem was to be this huge coal-fired power plant, the first of its kind, not just in Kenya, but within the region, the East African region. The contract for what was awarded to Amu Power, which is a consortium of local organizations and some Chinese organizations who build, own, and operate it under a 25-year power purchase agreement. So really, the litigation that underpins this started with an environmental impact assessment process, and most of us will be familiar with them, processes by which the potential impacts of a project are assessed against mitigation measures, certain conditions are put for whoever's planning to implement the project. That process had a number of challenges. And so communities in Lamu ultimately, once an environmental impact assessment license was issued, filed an environmental and administrative challenge to the EIA license. They did this on a number of grounds. And this isn't the full list, there are additional grounds as well. But I think what's worth highlighting here is the fact that climate change was not a central argument. In fact, what was central to their argument was the inadequate nature of public participation and their engagement. And I think this is just, as opposed to other forms of climate litigation, I think when people are assessing what counts as climate change litigation, it's often easy to lose track of cases like this, where climate change might not necessarily be the anchor or the key argument, but ultimately might result in outcomes which result in climate action or give progressive sort of judicial decisions around the assessment of climate impacts. So just on that point, it might be worth going to what, in terms of the arguments around climate change. So one of the central arguments here was that by that time, Kenya had a Climate Change Act. It imposed certain responsibilities to consider climate vulnerabilities and impacts, which hadn't been done, or so the applicants argued here, hadn't been done adequately. So, and they argued also that, you know, implementing a project of this nature was also going to be inconsistent with Kenya's climate obligations under the Paris Agreement. So in response to that argument, really, what the project proponents said was, well, one, the Climate Change Act had only been enacted that year. It wasn't very clear yet what it required. And so they hadn't really given sufficient attention or consideration to some of the potential climate impacts. In evidence, it came out that there were certain areas where they had proposed to set out certain components of the power plant that were prone to flooding, that this was likely to be exacerbated by climate impacts in the coming years. And these hadn't been addressed within the context of the environmental impact assessment report. And what the tribunal said, because the case was filed before our specialized environment tribunal, was that it was not enough to say that there's lack of clarity either in what the law requires or the nature of the impacts. And here they applied the precautionary principle to say that where there's lack of clarity, they would exercise their jurisdiction to stop the implementation of the project rather than to allow it in the face of the lack of clarity. I'd like us to take just a few steps back, just with the context in mind in terms of this competing tension between development versus climate impact, and also trying to bring in certain concepts around climate and environmental justice, because this was definitely central to who filed the case. So the main applicant in this case was Save Lamu, and Save Lamu is an umbrella organization that brought together a number of various community-based organizations representing the interests of fisherfolk, traders, and other people who have called Lamu home for a number of years. It also included 4 residents from Lamu who had been part of the impact assessment process. Now, why is this important? One, it's because of the nature of the arguments. Environmental impact assessment processes in most jurisdictions carry a huge component that requires public participation. So it made sense when crafting this and thinking about who should file it to put at the forefront those who I think are closer to the project, likely to face the brunt of impacts, and people who had personally been involved in the public participatory processes. And I think this just highlights some of the issues when we talk about climate and environmental justice, that disproportionate scale where those who bear the most impacts often tend to be least represented in decision-making processes. Though in Kenya, our standing provisions are quite liberal, so it was not a restriction, but in other jurisdictions, I think opting to file a case by those who can demonstrate direct injury or who have been part of the process might be a consideration. In this case, it wasn't. I think the consideration was really in terms of the nature of the arguments and then who then would be best to tease out some of the key arguments around public participation. Then in terms of approach, what does this mean? If we're thinking about, again, climate justice and thinking about just the evidence that's out there in terms of how those who are marginalized and vulnerable are likely to face the greatest impact, then it really meant that there was a lot of capacity building that had to be done within Lamu. This was the first coal-fired power plant, as I've mentioned, so there was really no context to this. We really didn't know what to expect, as opposed to impact assessment processes, say for a road, for example, where communities might have experience based on other projects. And so the starting point was really building an understanding about what does a coal power plant entail? What are some of the potential impacts for communities, just generally? And then secondly, what does this mean for them in terms of their rights under the law? So the argument starts very large scale in terms of Vision 2030 and energy access for the country and broader development goals. But what does this mean in terms of marginalized communities and some of the more direct impacts that they're likely to face? And so the legal strategy right from the beginning, when the environmental impact assessment process commenced, had to also bridge that gap. So connecting communities in Lamu with other communities, say in South Africa, who have had coal plants established within close proximity to where they live, so that they can understand some of the potential impacts on their livelihoods, their health, and other areas of their life of importance. Now, this became really, really important because ultimately in 2019, a decision was issued canceling the environmental impact assessment license. A huge reason for that determination was in terms of public participation. And a lot of the arguments were really led by those who had been part of the EIA process. Their experience in raising questions around the potential impacts to health, to climate, to some of the marine ecosystems where they fished, and they fished for several years, to which there had been insufficient information. I'm hesitant to go into the detail of this because I think most of us will be able to find the judgment and read it, and I can also share it. But essentially what happened is the communities were engaged, but at a very early stage in the process, where not much had been done to study some of the potential impacts. And so a lot of the questions that arose in terms of the impacts, whether to the marine environment, to health, didn't receive any adequate answers. And so by the close of the EIA process, even though you had this voluminous document that seemed like it covered all its bases, a lot of questions still remained unanswered. And what was really powerful, I think, in terms of this case, in terms of the approach that was taken and making sure that those who are closest to some of these projects likely to bear the biggest impact, was their ability to draw from other experiences. So I think there was a lot of exchange, particularly with South Africa, where, as Nicole mentioned, there are a few coal-fired power plants, but also to be able to tie that as well with their understanding about some of the procedural requirements and the law. So that's actually what anchored the court's decision and outcome in this. I think the second thing that is worth mentioning in terms of these sorts of cases is what happens outside court, not just what happens inside court. Those of us who follow discussions around climate change litigation in the continent may have heard of Decolonize. And by sort of building a strategy that not only focused on legal arguments, but also some of the participatory aspects of decision making. There was this organic sort of growth of a community of people opposed to the establishment of coal locally within Lamu, and then it just grew also nationally, because then the conversation then connected to what are some of the economic impacts. One of the arguments that was raised in their appeal was around the economic justification. And even though the tribunal disagreed with the applicants in its decision, I think in the court of public opinion, there was this growing movement locally, nationally, and internationally of people who were assessing and trying to tie some of the arguments around the economic justification. And one, I think, can argue that this also helped just raise and highlight this as not just a case about residents of Lamu, but a broader national issue and potentially even a regional issue. And so if one is thinking about lessons to be learned around this, it's that project-based litigation definitely can be a start. It might not necessarily result in favorable outcomes or outcomes that necessarily directly address climate change impacts, but at the same time, it can be a flashpoint for a broader discussion around climate change and climate impacts nationally, regionally, and across the continent, because I think that has been one of the successes, because the decolonized movement has grown and definitely really anchored a discussion around climate change and whether we need coal in the country, whether it makes sense economically and whether it's viable. And so definitely at Natural Justice, one of the lessons we've learned is to weave, I think, both strategies where you're thinking about both your strategy in court, trying to anchor it in some of these participatory requirements, some of these procedural requirements in such project-based litigation, but also connecting that fact that you're starting with the community and those who are affected to also build a broader conversation at the local level, at a national level and international level. Because I think in the context of climate change, you definitely need to be attacking it from several fronts and covering different angles, both inside court and outside. I think I'll leave it there for now. Thank you.
Thank you very much, Mark. If you can stop sharing the slides, please. Again, I found this absolutely fascinating. Some aspects were somewhat similar to what Nicole was mentioning, but you also brought new aspects to the discussion, which I'm sure we will explore in greater depth in the Q&A with all the participants, many of you at this webinar. I'm going to move now to Nigeria, and our colleague, Dr. Pedi Obani from the University of Bradford, give you the floor, and I'm looking forward to your presentation.
Thank you very much, Francesco, and thanks, Nicole and Mark, because I think most of what you said resonates really closely with what's going on in Nigeria, even though it is not in the mainstream literature that we've got climate change litigation, and more importantly, within the context of this conversation, project-based climate litigation. I have a few ideas in my slide, which I'll share with you very shortly. So the essence today, my talk is going to be on the current landscape and recent developments on project-based climate litigation in Nigeria. Like I've said, when you look at the databases on climate change litigation, there's only one case that's mentioned from Nigeria. And if we think about it within the context of project-based climate litigation, it may not really fit in nicely, but that's one of the issues which I'll be discussing within the next few minutes. To start with, to give a bit of a background, climate change impacts are real within the Nigerian context. Now, studies have shown that there are growing concerns about climate change impacts, particularly concerns around the extreme heats. But in addition to extreme heat, there are also concerns around drought, erosion, flooding, agricultural yield and food insecurity as a result of climate change, water insecurity and sea level rise. And there's practically no part of the country that isn't experiencing one of these problems in one form or the other. And in addition to this, there's also insecurity concerns that are increasingly being linked to climate change impacts. Now, where does this leave us in terms of greenhouse gas emissions? For Nigeria, when you look at the updated indices, which are prepared by the government a few months ago, would find that most of the emissions come from the energy sector. After the energy sector, we have agricultural, forestry, and other land use. So AFOLU, that's also a big contribution to greenhouse gas emissions from Nigeria. And then you have the waste sector and other product use. And the reason I think it's important to emphasize this is that indeed, climate change litigation will very likely continue to grow in the Nigerian context in connection with these same sectors that are the main sources of greenhouse gas emissions. To also put this in context, in 2015, Nigeria's per capita greenhouse gas emissions amounted to about 2.8 tons of carbon dioxide equivalents, whereas the global average was 7 tons. So if you look at it like that, it may seem like, well, we don't really have too big a problem from what's going on in Nigeria. But again, Nigeria remains one of the largest emitters of carbon dioxide, especially from gas flaring, which incidentally is one of the issues that has been addressed by the courts, but still remains a big problem even today. Now, do we have climate change litigation in Nigeria? It depends on who you ask and depends on how you look at it. From my perspective, and this is also supported by the literature, there's been a lot of litigation around oil production in Nigeria, around oil pollution especially. Now, if we come at it from that perspective, and we think about the fact that any action is geared towards addressing or putting a stop to oil exploration activities that actually increase greenhouse gas emissions, in a sense, actually contributes to the larger goal of climate change litigation, which is to ensure that countries, private individuals, everybody actually does what needs to be done in terms of ensuring climate change mitigation and, of course, adaptation to the extent that communities, individuals, and groups that are affected negatively by climate change are actually supported in the best possible way to be able to adapt to the consequences. So to that extent, we find that people in host communities for oil and gas projects in Nigeria and their representatives have instituted loads of actions in domestic courts, but also in judicial and quasi-judicial fora at the regional and sub-regional levels. Now, some of these cases have been retrospective largely. And again, this is tied to the fact that a lot of it talks about, a little bit tries to address pollution problems. But beyond that, many of these cases are also built around tort liability and human rights protection. Again, tort liability and human rights protection in connection with oil and gas production activities. Now, while a lot of this, again, means that this comes from a very anthropocentric perspective, so it's mainly about the individuals involved, the communities involved, and very often the relief is damages. There's still something to be said about how this contributes to changing the activities, the operations of companies and the governments in those communities in a way that contributes to climate change action. Another thing that's important to note is that within the context of climate change litigation in Nigeria, it's not only about environmental protection laws in the formal sense that we know it, but there's also a lot of links to land rights, common resources, which again provides some background that can actually support climate change litigation in the long run, because this idea of protecting the common resources, this idea of protecting intergenerational rights, this idea of protecting land rights, not just for the individual, but for the community and then for unborn generations, which is linked to customary law, customary rights, customary ownership issues of property, would also be an enabler for climate change litigation going forward. And I would say that cases that already build on this within the Nigerian context could actually be considered as part of the body of cases that could be considered climate change litigation in a sense. Now, what are the historical challenges that these cases have faced? One of them has been local standard requirements. A lot of the times, the litigants have had to prove that the problem, whether it's gas flaring, whether it's oil pollution, and the related damages haven't affected them alone, but no, haven't been just general problems, but have affected them in a way that justifies their instituting an action in courts. And in the case of Oronto Douglas, for instance, it was one of the reasons why the case couldn't go on, because it was the plaintiff had to prove, or the courts required that the plaintiff prove, that the LNG project would affect him in a way that would justify standing. Another historical challenge has been a very pro-economic outlook from domestic courts. We all know, well, it's common knowledge that the oil sector contributes immensely to Nigeria's foreign exchange earnings. It also contributes significantly to the economic development in the host communities, but also at the national level. And as a result of this, it would appear that the courts have been reluctant to give rulings that drastically affect the oil and gas sector and operations in that sector. So again, what we find is that judgments are given when the courts are approached for issues of gas flaring, oil pollution, affecting land rights, affecting the environment, affecting human health. Damages could be awarded, but the damages wouldn't be awarded at a level that actually goes to affect very significantly the economic operations of the companies or the government's interest in that community. So this economic outlook has been one of the historical challenges. And another one has been lack of enforcement. And I would say lack of enforcement because when we go back to the Benmore case, which is very often cited as climate change litigation in Nigeria, even though the court declared that gas flaring was a violation of the right to life, was a violation of the right to dignity, and in fact was a violation of the government's responsibilities for environmental protection. This was in 2005. Up till today, as we speak, there are still cases of gas flaring. What we find is that the government is now taking steps. There are policies in place, there are programs in place for the commercialization of the gas flares. But this has been mainly from an economic perspective. So it hasn't been so much that, well, yes, the environment could be an antecedent and there could be incidental benefits for the environment. But the main concern has been to commercialize the gas flares as against ensuring that this does not continue in order to prevent greenhouse gas emissions. So this has been a challenge to the extent that even when there was a subsistence, even when there's a judgment in place that's saying halt these operations, the ability to enforce that judgment is in question. And I think it points to this almost the weaknesses, or it centers our minds on considering the real strengths and limits of legal responses to climate change. Because it is one thing to have a law in place, it is one thing to have a judgment in place, but to actually be able to see enforcement is something that needs to actually happen to ensure that climate change litigation and other legal responses to climate change problem actually contribute significantly to addressing the problems in real terms. Another historical challenge has been from the angle of environmental impact assessments. So Nigeria has an Environmental Impact Assessments Act from 1992, which requires that if a project or if an activity is likely to affect the environment or would have significant impacts on the environment, then those impacts need to be considered and steps need to be taken to mitigate those impacts. While this is provided for in the Act, there's still a lot of discretion that is granted to the agency to determine whether or not enough has been done to mitigate those impacts. So what we find is that the Act exists in terms of the Environmental Impact Assessment Act, but the real benefits of the Act in preventing environmental impacts, significant environmental impacts from projects, from activities, development activities, hasn't really been felt in real terms. Now, as to whether or not climate change impacts could be considered within that context, even though climate change isn't directly mentioned in the Environmental Impact Assessment Act of Nigeria, I would say yes, because we're looking at a law that was made in 1992. But this law talks about environmental impact, and we know as we speak today that climate change is one of the main environmental problems the world is facing, and even Nigeria is facing. So for me, it wouldn't be so much a problem of showing that there are significant impacts in terms of climate change and greenhouse gas emissions, but the problem would be more in terms of the politics of it and in terms of ensuring that the agency actually does enforce takes action against an activity or a project on environmental or climate change grounds, as against saying that, well, we're satisfied that the company or whoever's proposing this project is going to take steps to mitigate the environmental or the climate change impacts. Now to the current landscape. Nigeria is one of those countries that has really good catalog of environmental laws. And when you look at the climate change aspects of it, it's no different. So Nigeria has signed up to international climate change commitments within the context of the UNFCCC, Kyoto Protocol, the Paris Agreement. Like I mentioned, we recently submitted our updated NDCs, which clearly spell out that there would be 20% unconditional contribution below business as usual by 2030, and conditional 47% contribution, which will be contingent on international support. This is actually an improvement from the previous, which was the initial NDC that stated 45% contingent on international support. So on paper, we would say that we have international climate change commitments, which could actually support the institution of project-based climate litigation in Nigeria. So that's part of the current landscape. And I've added the case of SERAP and NNPC there because that was a case before the ECOWAS Court of Justice, in which the court clearly spelled out that the country could be held to account for failing to meet its international obligations. So while treaties aren't self-executing within the Nigerian context, the ECOWAS Court of Justice decision shows that international commitments that have been entered into by the government can be enforced against the government. So it will not be enough for the government to say, well, this isn't from part of our domestic laws, if they have gotten into international commitments relating to this area. So within that context, Nigeria's NDCs provides a good supporting basis for instituting climate change action or litigation. In addition to this, when we look at the domestic level, we also have enabling laws and policies. So there's the Constitution of the Federal Republic of Nigeria, which, while it doesn't guarantee a right to a healthy environment, actually does mention the protection of the environment as part of the state's responsibilities. Now, there's been this debate around, is it justiciable or non-justiciable? But currently, we've had a decision of the Supreme Court, which clearly indicates that that section of the Constitution can be read in conjunction with other domestic laws to ensure that the government is held to account, and actually the right to a healthy environment or the right to environment can be instituted or enforced against the government. So it is no longer a question of, is it justiciable or not? It does exist in the Nigerian context and could be a basis for actually instituting actions for climate change. I've mentioned the Environmental Impact Assessment Act, and like I mentioned previously, that has its weaknesses in terms of practical application and force. And that's currently on the review. So hopefully the next reiteration of the act will be stronger in terms of the provisions and in terms of checking that the political class does not exercise discretion in a way that goes against the spirit of the law. We also have a Freedom of Information Act in Nigeria. And then we have the NESRIA Act, which regulates air pollution, air quality standards. So those are all enabling laws which could actually sustain climate change litigation in Nigeria. And these are laws, especially the Freedom of Information Act and the NESRIA Act, these are laws that have come after the memory decision. So beyond the Constitution, which was relied upon in the Memory Act and the African Charter on Human and People's Rights, we now have other laws that could support litigation. In addition to this, we have policies like the National Climate Change Policy. We have the National Action Plan to Reduce Short-Lived Climate Pollutants. We have the REDD+ strategy, National Forest Policy, National Forest Investment Plan. And then we have a Building Energy Efficiency Code. So like I said before, we have all these laws and policies which on paper seem really brilliant. But then it's all about the enforcement, and the extent to which these laws and those policies can actually ensure that climate change mitigation and adaptation becomes a reality for Nigerians. And I would say that these could actually be a starting point in terms of building a case, around these issues. Now, I asserted there that there was a recent removal of fuel subsidy in response to low oil prices in the global markets. This is around the period of COVID-19 as well. But I said this is questionable. And the reason I've said this is questionable again is that while the removal of fuel subsidies could be seen as a way of actually promoting climate change action, within the Nigerian context, we have a situation in which it is again linked to economic reasons. So all of this form the part of the current landscape. Now, recent developments, we have the National Gas Expansion Program, which again is focused on enhancing the development of liquefied petroleum gas for the domestic market, as well as compressed natural gas for export markets. We also have the Petroleum Products Pricing Regulatory Agency that is removing the gasoline price cap, again, removing fuel subsidies in order to encourage transition to cleaner fuels such as gas. And then we have the Climate Change Bill of 2021, which contains very brilliant provisions, including provision for the establishment of a National Council on Climate Change Fund, carbon budgets, provides obligations for ministries, public entities, private entities, also provides for the participation of civil society groups, and provides for climate change education. So all of this provide the current landscapes. But I would say that within this context, it is important to remember that the economic argument is still a major concern for the government of Nigeria. So we have to think about how do all these laws come together to address this predominant economic focus while building on the gains that have been made in recent court decisions, such as the liberalization of the standing rule and then the growing interest of the Supreme Court on issues around sustainable development and climate change. Thank you.
Thank you very much, Pedi. Perfect. Okay, so we have heard 3 excellent presentations. We have plenty of time for a discussion with our speakers. I have noted down some of the questions that have come in, and some of them may be more directed to one speaker, but I'd like to start with one that I think can draw the attention of all 3 speakers. I will kindly ask the speakers to respond, and I know it's difficult, as briefly as possible, because that way we can get more questions in and it will be a bit more juicy, let's say. And I also have quite a lot of comments myself, but I will refrain and I will bring them to the conclusion part of this webinar. So the first one is a question that you find in the QAA, and in a way has already been answered, I think, by Nicole, but I want to bring it back in because it's from Helen Kambach. She asks, have these legal challenges led to a rethinking or rewriting of the South African electricity policy? And let me just frame it for all 3 of you. Does successful climate change litigation lead to a change in national energy policy? So in the 3 countries that we have talked about, is there or is there not more, for example, renewable energy production? And how can you make the connection between the case that has been successful in brackets and this increase in, say, renewables? I'll start with Nicole, but I hope you don't mind, Mark and Pedi, if I ask you the same question. Nicole.
Sorry, I couldn't find the unmute button. Yeah, that is a very good question, and I don't know if I vented my frustration appropriately in the chat, but I mean, it's obviously, I think it differs from country to country, and conceivably it should result in a change. I mean, certainly our Thabametsi win, as I said in the presentation, meant changes to how climate impacts get assessed, and guidelines and policy documents have come out of that. But the energy planning policy is a bit different because it's dealt with under a different department and a different minister. And South Africa's energy minister is, to put it bluntly, quite set on coal for the foreseeable future. Our electricity plan has been revised since that case, and it does provide for less new coal than initially, but it still makes provision for new coal. What we have been able to do is, using a lot of the modeling that I talked about, showing costs, we've really been able to build up that argument that this doesn't make financial sense apart from the climate impacts and everything else. And we're actually now in the process of preparing a legal challenge of that decision, which is, it's very different to challenging an environmental authorization, because what we're now planning to do, and we've cautioned the energy minister that we are planning to bring litigation unless they abandon their plans for new coal. But essentially this would be a challenge squarely and directly of essentially that government's policy position to continue with its plans for building new coal projects, despite the overwhelming evidence of the climate harms and the threats to human rights and constitutional rights. We have a very strong constitution in South Africa that does lend itself to that kind of a challenge. And importantly, given the existence of feasible alternatives, clean alternatives that don't have these impacts, that are more affordable and cheaper. I mean, it just, yeah, so that's unfortunately where we are now, because, you know, despite all of this, we are still seeing plans for new coal and now more gas projects, which is, you know, the thing that's really concerning us over in South Africa at the moment. What I can say as a parting comment is just that what was interesting to note is in this revised energy policy, and we've seen it in a number of statements made by the Minister of Energy, almost this resentful comment that keeps coming up saying, you know, that they want coal still to be part of South Africa's energy mix for the foreseeable future, but these projects have been heavily delayed, and we need to make sure that they are able to get finance and that they can overcome these hurdles and burdens of litigation from, you know, these pesky environmentalists. So clearly our litigation is having an impact, and they're now factoring in longer lead times for coal projects because of the fact that they know that they're going to be challenged. So whereas before they would assume that a coal project could be up and running in a short number of years, they actually say that, you know, these projects are likely to be challenged, so we need to make more time for them to get the go ahead, which is very interesting.
Thank you. Thanks. Thank you very much, Nicole. And this raises also the issue of one climate case then followed by a further climate case, and this like a chain of climate cases, and I'm sure that you're well aware of how this works and so forth. So I'll give the floor to Mark from a Kenyan perspective. Is there more renewable energy production, and is that in any way linked to climate change litigation, in your opinion?
In my opinion, I would say no. I think even before this particular case was filed, I think there had been some indications from our president that Kenya wanted to invest more in renewable energies. And so we've seen a number of wind power projects come online and a huge push for geothermal energy. Sadly, though, as Nicole is saying, there's still this commitment to coal being part of our energy mix. You see it still as part of our national energy policy. And then more recently, we've had our least cost power development plan, which sort of, you know, sets out the plan for the energy mix for the next couple of years. Still make provision for coal, but do it in a phased out manner. So rather than trying to build in one 1,000 megawatt plant, the proposal is to now phase it up over a couple of years. I think the other point though, and it's something Nicole mentioned as well, we might not necessarily be able to show a direct link between climate litigation and policy change. It definitely has an impact in terms of financing and people pulling out and seeing these fossil fuel projects as being risky. So that's the other aspect of impact. Thanks.
Thank you very much. And again, Pedi, if I can ask you from a Nigerian perspective, do you think there's that link between litigation and potentially a change in energy policy?
Thank you very much. I would say not really. So there's emphasis on renewable energy as part of the energy mix. And there's also emphasis on stopping gas flaring, like I mentioned, but I would say the motivations for this aren't necessarily because of climate change litigation. And very often it would even seem as though the law is made to support the plans that are already in place. So the government wants to improve wants to improve renewable energy as part of the energy mix, and then puts in place tax rebates and other incentives, you know, so that people can actually go and buy solar panels for their houses and all that. So it's more an economic, for me, it's more an economic issue, and it's more an issue of energy security, because we have hydro systems that are failing, you know, that are now old and all that. So the government is looking for ways of improving access to energy. So if it's going to come from renewable energy and it's affordable, and very often renewable energy is decentralized. So that has advantages in that sense, but it's not so much because of climate change litigation, I would say. And I think another thing to consider, I'll just say briefly, is this issue of gas being considered as a transition fuel. And all the discussions around it, even at a global level, is something that makes it a bit difficult to even insist on stopping projects that are linked to gas. So as far as government is concerned, investing in gas is a plus, both from an economic perspective, from an environmental perspective, and from a social perspective, and that's what it is. Thank you.
Thank you very much. The questions are coming thick and fast. Thank you. Can I kindly ask you to write the questions again as succinct as possible, so I can try to capture as many as possible. And also I'm seeing people introducing themselves in the chat. Please do so, especially your link with climate change litigation. It would be much better to be physically all present and have a coffee afterwards, but this is the best we can get. The chat where you introduce yourselves and we get some networking going there as well. So my second question, and this was posed in the chat, in the Q&A to Pedi and to Nicole. So feel free both very briefly to comment on it. And it was about, and I'll paraphrase here, but the questions do come from Richard Raturi and one that has been answered by Kumbulani Maposa. So the first participant asks Pedi, what if there would be a climate change act in Nigeria? Now, I think Pedi may want to clarify on that because I do think there is some legislation in Nigeria about climate change. And for Nicole, the question was a very interesting question from a Zimbabwean perspective. If there had been, or if there were to be an impact assessment related law, would that make any difference? And I think the wider question is, having legislation, will that lead to more or less climate change litigation? And I can anticipate that this is one of the questions that with my colleagues, I see my colleague Joanna Setzer and the participants who have already been discussed to events that have taken place at LSE in early July, and will be taken forward also at our COP26 event at Strathclyde University. So maybe let's start with Pedi this time. This link between legislation and litigation. Can you expand on that? What is your brief reaction to that?
Thank you very much. I would say yes. I think that with the litigation, with legislation, it will be easier for people to have a direct basis, for holding whoever's responsible to account based on what is in the law. So in Nigeria, for instance, with this provisions, if this comes through, and we actually have provisions on carbon budgets, we have provisions on the Council for Climate Change, and then we have provisions clearly spelling out the responsibilities and obligations of different parties. I think that will be a very good tool that will then promote climate change litigation. Thank you.
Nicole, is there anything you want to add to that, or shall we just move to the next one?
I would just second exactly what Pedi said. I think it does provide a necessary hook at present. Emitters have no emission limits for greenhouse gases, and we're finding it to be increasingly difficult to hold the large emitters accountable. Of course, it also largely relates to government's own position in terms of its emission commitments. But a climate act is something that we've long been advocating for in South Africa.
Okay, thank you very much for that. I'm just looking at a question which actually aligns very much with one of the points I wanted to make, so I'll bring it in immediately. And it comes from Vedanta Kumar, and you'll find it in the open questions in the Q&A. It says, in the countries that you focus on, to what extent do you feel the rest of the civil society movement has embraced litigation as a critical pillar of climate campaigns? I ask this because I think it was Nicole or maybe Mark, somebody mentioned the court of public opinion as something that happens before, during, and after climate change litigation. But I am curious, and obviously I do not know enough, so I really want to hear from you, again, maybe from each one of you, very briefly from 3 countries, starting with Mark maybe this time. The wider civil society, however you defer, it's a very subjective thing, what is wider civil society? From your own perspective of wider civil society, do you think they are looking at courts, they are looking at people like yourself as part of a wider climate campaign? Mark.
I'm tempted to say no, not yet. And part of it links with a number of issues. If I understand you right, first, I think if you're talking about cases or litigation that centers on climate change, there's still very few of them. And one of the challenges, I think, is something that I think someone also mentions in terms of the evidence that you need, and getting access to experts who can provide you with that evidence that you need is still a bit of a challenge. Definitely in Kenya, it's a challenge. And it comes with also huge costs implications. So that might make it a bit prohibitive. But I think it's still a little too early, definitely, for Kenya. We've only had a Climate Change Act, say, for for 5 years now. We don't have regulations, so there's also a bit of lack of clarity around specific obligations or legal hooks against which you could hold different actors to account. So I think those are still some barriers which make this not yet as widespread as we see in other jurisdictions.
Thank you very much, Mark. Maybe Nicole, just very briefly from a South African perspective, how do you see this developing?
Yeah, it's an interesting question. I mean, I think it's also worth acknowledging that a number of important cases that may have beneficial impacts for the climate aren't necessarily climate cases. So a lot of litigation and cases we've actually brought rely more on industrial pollution and health, which certainly has a lot more support from community-based organizations on the ground, given that a number of them are living in very polluted areas and are suffering the tangible and direct effects of this devastating air pollution in certain parts of the country. So we have brought a number of those cases, and if you speak to a number of those people, they're not that interested in climate change, but they are very much interested in cleaning up the air and the water in their communities, which again is very much linked with resolving the climate issue. But just one last point. I mean, I think the civil society movement is quite diverse. So within it, there are also a number of groups and organizations that are very keen on bringing more climate litigation and challenging these decisions of government. What I can also say, though, is that I think we all realize that it's not just about the litigation. The litigation is one component of a much bigger movement. It needs to be complementary, and it's not the only part of, or it's not the strategy in itself. The strategy is much broader than just the litigation. Thanks.
And very briefly, Pedi, if you can, just from your own viewpoint from Nigeria, would you think there's this link, or it's an increasing link or a decreasing link?
So I would just say that we have to remember that climate change litigation is not cheap. And in fact, no litigation is cheap. So if the majority of the grassroots advocates and there's this wider grassroots movement we're talking about, or advocates we're talking about, do not have the resources to sustain litigation and even climate change litigation, then it would mean that for them, it wouldn't be the first thing to go after, even when they see successful cases. So I think that it would benefit the climate change litigation movement to actually be inclusive of other strategies being used by other advocates already, and at the same time to see how they can incorporate the priorities of these other community groups, because then it becomes more democratized, and then it even has a stronger force, because when you get the judgments in court, you actually have the critical mass to force the hands of the government and the private entities to enforce that judgment. Thank you.
Thank you. And I think this actually leads to a follow-up question, which I really hope you don't mind me asking, but I will anyway. And this sparks from this question about costs. And I think Nicole actually finished, or was almost towards the end of the presentation, saying these are very costly cases. They're not just done on a shoestring, And one of our participants, our own SCELG researcher, Edna, actually asks that, and asks very pertinently, who pays for climate litigation cases, and how does this affect the number of cases put forward? Before anyone who, in this case, I'll maybe just ask somebody to volunteer. I know it's a difficult one, but this is not by any means just a challenge/problem in the African continent. It's a huge issue in any country, including many countries in Europe, including in the UK. So let's not think that this is just a problem for countries in Africa or Latin America, like we have seen in the previous webinars. But if any of you can, just shed some light on what is the finance world behind these cases? How does it actually work? Is there anybody who wants to give it a go?
Do you mean who funds our cases?
I think the question, yeah. So the question from Edna is, who pays for climate litigation cases, and how does this affect the number of cases put forward? I think also the question of how does it affect Does it mean one has to be more strategic? Does it mean you have to really focus on the case that will give you more impact? I guess that's what's in Edna's thinking when she asked this.
Sure, I'm happy to answer that and others can step in. It
Thank you,
very
Nicole.
much depends on the funder. I mean, there are some funders that very much prioritize, the big high impact cases. Others are, keen to support anything. I think it depends on the strategic direction of the funder. Most of our work is funded by the European Climate Foundation, the Fund for International Litigation for the Environment, Open Society Foundation. So all of our work is funded by philanthropic organizations. I don't know if that answers the question.
Absolutely, absolutely,
Okay,
Nicole, and thank you very much for answering that question. Okay, unless Mark and Pedi want to jump in, we only have 5 more minutes for the Q&A, and then I'd like to have a few minutes to conclude. And I'm afraid some of you, the participants, I will not be able to get to your questions, but I see that a lot of them have been answered in the Q&A, and I really thank Nicole, Mark, and Pedi for doing that as well. Let me bring 2 rather more legal and almost procedural questions. One is, it's a very, very long question. I will not read it out loud, but it starts really with, it's from Richard Raturu. My question is how we can handle the issue of evidence for admissibility. And then it goes on. The way I interpret that is a question of proof, of causation, of science. So maybe I'll ask Mark more from on the grounds and within a case perspective, and maybe Pedi more also from an academic perspective. In the African context, in the context of the case you have been working on in Kenya, has elements of proof, causation, science been important? How have you dealt with them, Mark?
So not in this case, because I think what we were raising here is that there's a risk and trying to demonstrate the likelihood of that risk. And right now, based on the science, I think there's very few people who would challenge that there's not a link between certain impacts and increased greenhouse gas emissions. I think you're likely to run into that challenge for more tort-based litigation, where I think there's a huge discussion right now around attribution science. But certainly when you talk about environmental impact assessments, I think it's enough just to show that there is some risk and there's enough scientific evidence there to create that link, especially in the African continent and places that are particularly vulnerable to climate impacts.
And I think this is very interesting because it's not about bypassing the question, but it's actually about underpinning it on the strength of science on that. So it's a very interesting point. Pedi, do you want to just expand more from a wider perspective, maybe?
Thank you very much. So 2 things really. Of course, the first place would be to look at the Evidence Act. And I think that, for instance, in Nigeria, there's been revision of the Evidence Act in response to actually increasing the kinds of evidence that can be presented in courts. So documentary evidence and other newer forms of evidence. Now, in the context of the litigation that has already occurred, very often when it's taught, even things around Rylands and Fletcher, the escape of oil, causing pollution. So you see the evidence is really clear in terms of the damage that has occurred. But now, if it comes to climate change and attribution, that kind of technical aspect, I would say that because of what's going on in other jurisdictions, I think that would also add to the evidence in Nigeria. So I don't think it would be starting from scratch to try to prove that climate change is occurring and all that. There's already so much that's been done that can actually form a basis for evidencing, whatever claims that could be brought forward in courts, even within the Nigerian context. Thank you.
You're welcome. So I'm going to take the privilege of being the chair and ask the question myself, and then I will draw this interesting webinar to a conclusion. And my question to, again, very briefly, all of you are welcome to answer, is about judicial exchange in climate change litigation. And what I mean by that is, I'm curious to know whether in the 3 jurisdictions that you have been working on or you have been talking about, be it the judiciary, be it those who bring the cases, be it those who receive the cases, actually talk to those same actors in other African jurisdictions, or even beyond? And how do they do it? Is there a network? Is it informal? At the end, it's a small world and we all know each other to some extent. But or do you think this is something that is needed? This judicial cross-fertilization, if we want to call it, with a nice, cool word. So I hope the answer is clear, because I do see it in other areas. To give you one example, rights of nature, New Zealand judiciary talking to the Colombian judiciary, and so forth and so forth. So I do wonder whether in the African context, whether there is that communication, that common language, those networks, and if there is, and if there should be more of that. So maybe let's start with Pedi this time, Mark, and then we conclude with Nicole this time.
Thank you very much. I would say yes, because already the fact that the courts will draw on principles of sustainable development, issues around climate change being a human rights issue, environmental protection being a human rights issue, it all shows linkages between what is happening domestically and international commitments, but also even the international development agenda and priorities. Now, how does this happen? One of the ways it happens is within the NGO space. I know that there are collaborations. So for instance, in Nigerian context, we have the Environmental Rights Action Group, which is also linked to Friends of the Earth. So those connections are occurring at different levels, and the jurisprudence is also linked to what's going on both regionally and internationally, I would say. Thank you.
Thank you, Pedi. Mark?
Yes, I think they are happening. And it just goes back to, I think, if you look on the African continent, there's a rich history of that cross-judicial sort of fertilization around human rights issues. When you talk about environmental justice issues and sustainability issues. So lots of cases being referenced even from regional decisions at national level. I think more of it is going to continue happening. I think we're also seeing a number of conferences convening and trying to start putting a spin like this conversation around project-based litigation in Africa. And this is now becoming available online. I think I've been part of some discussions that have had judicial officers as well. So I think there's evidence of that cross-fertilization. I think more of it will continue to happen and to be contextualized in a way that makes sense for the African continent.
Thank you. Nicole?
I have nothing really to add. I fully concur with what my co-panelists have already said. Yes, there are a number of activists, broader network organizations that are rapidly expanding as well.
Thank you very much. And I really look forward to C2LI itself to be part of that journey, let's say, of sharing stories, of sharing narratives, of sharing examples from different countries, and also for other parts of the world to learn from the very exciting developments that are happening from the African continent. So I'm going to take this to a close. I know I haven't presented all the questions in the Q&A, but I hope I found that a really vibrant and interesting Q&A session. And I really, really thank Nicole, Mark, and Pedi for their fantastic contributions and for staying with us until the end. I would also like to thank again Amelia Burnett and Lydia Omuko-Jung for organizing this webinar, for bringing it to life. Thanks again. I'll finish with just two more general comments, and then again, a save the date for the C2LI launch and our presence at COP26. So the first one is that there are so many things I heard today, which although focused on an African reality, I believe have a wider, even global connotation. The first one is really about the just transition away from fossil fuels. It's about the difficult relationship between climate justice and energy justice. And the one point that was mentioned several times was this focus in Africa to move to greater infrastructure and greater development. But the two really can bring that clash between just transition, clean energy, climate change. More infrastructure can mean more cement, and cement is very carbon intensive. More development, depending on how you frame development, may bring more oil and coal. So you really have that conundrum, which is actually even exacerbated, and I think Mark mentioned in the Kenyan case, from foreign investors. And China is there, but it's not the only one. So again, if we're thinking of the emissions from a new airport or a new project, well, should we start looking at who actually invests in that from a foreign direct investment? Huge, complicated legal matters and political, obviously. The second one that I'd like to conclude with is about the climate impact assessments. This is really where those who work on the ground, let's say, get their hands dirty, not just in ink, but let's say they really get their hands dirty. And just bringing this also to the UK level. In the UK, we do have some coal power plants and some oil offshore that may well still be explored. And actually, one of the reasons those who defend these policy decisions is that if you do an impact assessment, it's better to produce our own energy through coal and oil than import it from other dirtier places. I'll leave it to that because obviously there are ways to rebut that. But I do wonder whether in some of the countries we mentioned today, but also in other frameworks, the justification and then the challenge to these kind of projects is that it will bring more domestic jobs. It will bring more development. And that's where we really need to be careful not to antagonize people, because the last thing we want to do is for people to think that all those interested in climate change do not want jobs, but by the way, we drive our beautiful electric vehicles, which is not true. But there is that risk in Africa, but also everywhere else in the world. So I will leave you with that, and I will really, really encourage you to join us at COP26, either in person if you can make it to Glasgow, or online on Saturday, the 6th of November. We will be launching the C2LI at an event on climate litigation and the rule of law that we will be organizing together with the LSE, Grantham Centre, and the IUCN World Commission on Environmental Law. I hope to see many of you there, and thanks to all the participants, the speakers, for a very enjoyable webinar from myself. Thank you very much. Bye-bye.